SJC-13794, Commonwealth versus Cheri Maria Dobson.
Okay, Attorney Zendowski.
Yes, good morning. Attorney Zendowski here for Cheri Dobson. So in this case, we have multiple illegal pat frisk searches, ongoing Miranda violations, and improperly extended automobile stop, all which stem for a stop for tinted windows. So I'll start with the pat frisks. And so, as I said, we have a stop for tinted windows. And what Officer Fulham, one of the stopping officers, has seen is the passenger putting two hands towards the center console in the glove box and then kind of reaching forcefully towards his feet.
Could you get a little closer to the microphone? Sorry.
Actually, I was going to say the opposite, because the closer you get, the more feedback. It's amplified, so all you have to do is just talk normally and we can hear you.
All right, let's try here. Okay, so yeah, pushing something towards his feet. When he issues the exit order to the passenger, he says that it's because he didn't like what the passenger was doing near his feet. Subsequent, he issues the exit order to Miss Dobson. We have both passengers outside of the car, where he frisks, or both male officers frisk the passenger, Miss Dobson. Don't discover anything. Frisk the interior of the car. Don't discover anything. But the glove box is locked.
Can we cut to the chase? Was there probable cause to arrest for assault and battery on a police officer?
I don't believe so. In this case, she wasn't charged with the assault and battery in the district court. And so I think it was a description that she was pulling away. Yeah. And so
She doesn't have to be charged in order for there to be probable cause.
Okay. I still don't think that the facts and the video footage would support that charge, but I don't think
Suppose we disagree with you.
Okay.
What about inevitable discovery?
So inevitable discovery, I think, would go to this issue of voluntariness and perhaps, well, I guess if you don't agree with me on the probable cause to arrest, yeah, it would go to the voluntariness of how they obtained the keys. And so I think that their actions over the course of the stop sort of demonstrated bad faith, and they essentially coerced Miss Dobson into giving the keys. The police as a whole, both male officers and the responding female officers, through multiple illegal pat frisks, kind of scary things, barking orders, swearing at her. And I think importantly, just an ongoing blatant Miranda violation. We're asking all sorts of questions of her. Someone in handcuffs, clearly not free to go, and not giving her any Miranda warnings.
So I had a question about your Miranda argument.
Sure.
What is the statement that led to the discovery of the contraband? I
think essentially the statement is, it sounds a bit funny, but it's handing over the keys. It's that communicative gesture of here's the keys. And so
what's the legal doctrine that supports that giving officers keys is tantamount to making a statement?
Well, I think giving officers keys in response to a question, and I think I outlined it in my reply brief, but sort of with the Martin case, looking at that Martin case where there's a gun. But in
Martin, there was a statement, the gun is in the closet. Right. I was, the victim, alleged victim, is actually the culprit. There was a series of statements that were suppressed alongside the physical evidence.
Right. I'm saying that essentially with Martin and also Rodriguez, though, the result shouldn't have been different in Martin had the defendant pointed to the closet if the officer had asked, where's the gun?
But that would definitely be a communicative gesture. I'm wondering what legal authority you're relying on for saying or giving an officer keys being a communicative gesture.
I think I'd go back to then Rodriguez. It's the appeals court case that I think was kind of foundational to my case. But essentially that in that case, the defendant kicking off their shoes, towards the officer while they were handcuffed was.
But didn't the in that case, I thought that the defendant said, "It's my blood. You can go ahead and check it," and was being interrogated, I think, by the officers, and gave all sorts of statements as well.
Yeah.
So there were actual words that came out of his mouth alongside with the suppression of the blood evidence.
Ms. Dobson was giving statements. She was talking to the police. So there were words that she was saying. Ultimately, at the end, it was the handing over the keys. She's sort of a bit evasive on if she has the keys, but she was making statements in response to this police interrogation. So I think there were statements there, and then coupled with this physically handing over the keys, I think like
Yeah, I would have
Rodriguez.
thought your better argument might be the failure to give Miranda warnings goes into the totality of the circumstances as to whether her consent ultimately was voluntary.
I think I'll make that argument too. I think that's there as well. That they didn't give her Miranda, and that goes to the consent of handing over the keys.
On the consent issue, and the judge makes a finding, and you obviously need to challenge that finding. The judge looks at it as kind of a segmented way and takes a portion of the conversation or the interaction and says, there was consent here. She knew she didn't want her car to be broken into. Can you help us looking at the totality to figure out why there was no free and voluntary consent, given that segment the judge pointed to?
So I think that how the judge phrased that was rather neutral, and perhaps how the judge had phrased it might have been okay, but I don't think that's what was actually happening at the scene and with what the police were saying. The two female officers, before the dog even hit on the glove box, were talking about the police ransacking the car. They were talking about the police breaking the car. Then after, when this ultimatum is happening, they're continuing to talk about these police damaging the car. They're going to damage the car. And so the amount of times that they tell her that the car will be damaged if she does not hand over the keys sort of renders that improper. And I think there's...
How did the pat frisk figure into this calculus?
Well, I think that these pat frisks, same thing, that there's multiple pat frisks. They do a pat frisk initially, don't discover anything. After there's this little kerfuffle, do another pat frisk, don't discover keys. And so, but they continue to pat frisk her. They pat frisk her multiple times after that, sometimes long, sometimes short. The female officers show up, they pat frisk her. They haven't discovered anything, and they're just continuing to pat frisk her. It's, as Officer Fulham says, I will pat frisk you, referring to the passenger, but I'll pat frisk you 5 times, 6 times if I have to. They're going to continue to pat frisk until they find something, is what it must seem like to Ms. Dobson.
To give the judge's analysis her due, what she says is that the defendant stands her ground, so to speak. She's challenging the request for her keys. She's not really answering the questions, and she's just steadfast. And then the dog, and the police never cease in asking her for her keys. But the dog frisk, the dog hits at some point, and they give her one. They say, I'm going to give you a couple minutes to think about this. Police officers continue pressing her to give the keys, and she clearly makes a decision to give up the keys. And what I understood the judge's reasoning to be was that here you have a defendant who clearly was willing to stand her ground against considerable, you might say, attempts at coercion to give up the keys, and then this event happens, which is she now knows that the police are going to get into the glove box one way or another. So how do you respond to that?
Well, I think that all the coercive behavior, the pat frisks, the continued custodial interrogation it's sort of an attenuation issue, but this sort of overlaps that attenuation. And so they continue to interrogate her custodially. They continue to violate her Miranda warnings. There is really no break from the police. She's continually subjected to an interrogation until she hands over her keys. Until right before she hands over her keys, she hands over her keys in response to a police question. And so right until the end, they're doing this illegal interrogation, inappropriate pat frisks, kind of continuing before that, and all the mentions of damage before. And so I think that all goes to her voluntariness, that she didn't have a break from it. And so
Can you distinguish voluntariness from attenuation?
Good question.
I definitely see the argument that there's not attenuation in the sense that it's an unceasing, but the question is whether it was free and voluntary, and the judge found it was.
Yes. I mean, I think my argument is sort of the same, where it just is overlapping. And so the voluntariness is sort of, the question is roughly the same, that the lack of attenuation does go to the voluntariness. And so, and the fact that they didn't give her Miranda warnings at all, which is a factor for determining voluntariness of consent to search. And so it's all sort of wrapped up in one real messy parcel.
If we find there's furtive gestures to the glove compartment, right? The officer testifies to that and the judge finds that, right? And then we have a dog hit on the glove compartment. Is this consent issue just, again, meaningless because they have the right to get into this glove compartment at that point, don't they?
I think
I'm just trying to understand, even if you're right, this is not consented to voluntarily. Don't they have the right to get into this glove compartment? So I want to make sure I understand your argument about why that. How do we not resolve this case on those grounds as well?
I think got kind of two-part answer. So I would say that it would go to the improperly extended stop, where towards the floor, and then this glove box is locked.
But the dog comes pretty quickly, right? The dog, how quickly does the dog arrive? I thought it was surprisingly fast, but I may be.
It's 20 minutes, 25
it's
minutes.
20 minutes?
Yeah, the whole stop is about 20 minutes. So, it's in there, that kind of range. And so improperly extending the stop for the tinted windows, when we see someone reaching with two hands forcefully towards a glove box. There's case law that says, if police have a key, they can open up the glove box, a locked glove box, to search it. But nobody saw anybody locking the glove box. The glove box is just locked. And so I think I would argue that police have no ability to get in that glove box until they have probable cause. So we're extending the stop till the dog.
If they have probable cause, either because the nature of the encounter between the defendant and the police changes once it becomes physical, which the defendant initiated.
Yeah.
Or because there was probable cause because the dog hit on the glove compartment. If there was probable cause either way, either types of probable cause,
yeah,
before the defendant consented. In other words, all these other issues that you've spoken about, the constellation of facts that would, as I understand it in your argument, you're arguing would show that the finding that she freely and voluntarily consented was clearly erroneous. If there's probable cause beforehand, and even assuming there's all this problematic police behavior, why is suppression the appropriate remedy? The defendant may have other remedies for inappropriate police action.
Yeah.
But suppression, how does suppression remain one of them if there was probable cause before any of that stuff?
Okay. Yeah, this is actually the second part of my answer, I think. So essentially the police, through this coercive behavior, accelerated the discovery of that firearm. And so they, through this, I'm basically arguing they acted in bad faith, knowingly interrogating someone without giving them Miranda, knowingly pat frisking or threatening to pat frisk people multiple times without discovering anything.
The automobile exception, given them the ability to get into the glove box?
I don't think the case law right now says so without that key being present. I think it's sort of in between the cracks of the law there. I would also, real quick, on my previous point out it's an appellate court case, Farnsworth, where the police officer was also a firefighter, and he responded to a house in his firefighter role and observed all sorts of marijuana. Well, it was illegal back then, and a firearm. and then sought the occupant's consent to search, even though he himself had seen all of this evidence of a crime. And so the court still decided it along the lines of the consent, because I think it goes to the voluntariness of the consent goes to the coercion of the police. And so ultimately in that case, they found that the defendant was not coerced. There was a consent form. It was very above board in that case, but that question was still live. It was Farnsworth from 2010.
How long after they issued the exit order and Pat Frist, the defendant, did they ask for the key?
They immediately said, "Where are your fucking keys?" After the exit order of Pat Frisk, a minute maybe,
Right.
very shortly afterwards.
What
is
about
when
the Commonwealth's argument that the keys themselves were a deadly weapon?
Well, I think in this case that whichever the initial Pat Frisk, I guess, wouldn't discover the keys in their hand, perhaps then the next Pat Frisk could be valid. The first one that the male officers did, and they didn't discover the keys. So whatever the reasonable suspicion standard says, it has to make its nature readily apparent. And so they didn't find anything. And so I don't think they can continue to keep searching until they find something when they clearly haven't. So,
I mean, they knew the keys had to be somewhere because she had the keys and then the keys disappeared and they weren't on the ground. So I think they had reason to believe that their Pat Frisk was incomplete, which they clearly did believe. I'm going to ask the Commonwealth about this, but I would assume an additional argument, which I think was in your brief, is that the police have to actually be searching out of concern for a deadly weapon if they're going to search her for the keys for purposes of depriving her of a deadly weapon. And it's very clear, and the judge found that they were searching her for the keys because they wanted to get into the glove box.
that is true as well. Yes, they wanted in the glove box. They weren't particularly concerned about the keys, and they weren't particularly concerned about the safety of the situation either, where they kind of bring her over to the glove box or to the right next to the car in an attempt to get that glove box to open in case it was some kind of remote lock. And so they're not really having any safety concerns after the overwhelming police force respond, that clearly they have this situation in hand and under control.
Okay, thank you.
All right, thank you.
Hey, Jordan.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. And to use Justice Gaziano's words to get to the bottom of this case, what's this really about? This is really about the defendant's prolonged game of keep away, where she knows that she has the keys. It is not giving them up to a place where the police lawfully can explore, and that basically the whole 20 minutes is her playing this game and calculating the risk and probability of being found out. And where it turns is ultimately when she's told, we have a search warrant and there's going to be a consequence that is going to lie on you. There's going to be damage to your car that ultimately, you're going to have to pay for. And that is an independent reason that motivates her.
Are you suggesting that she was not entitled to hold on to her own keys?
No. So I'm not saying that because, and I do want to let you know that the first demand for keys in response to the question that the officers made was, let's see, the stop starts at 19. I'm just going to, when I refer to minutes, it's 8 o'clock and I'll refer to minutes. It's 19 and the first demand is, do you have the keys, which is on the side after the initial practice is at 23. So, and that is demand, and demands for physical evidence do not implicate Miranda. And especially at this point, it's more like a routine. We know there's usual suspicion, but this is more like to a traffic stop, right? It's rapidly evolving. So, I'm sorry, now I lost my train of thought about demand of keys.
Well, I'm just trying to probe your statement that she's playing a game of keep away. She had the right.
Right. Thank you for reminding me.
She had the right to retain her own keys.
Yes.
I mean, there may be consequences from that, but
Yes, she has the right to keep her keys, but I think what we also have to acknowledge is that the officers had a lawful reason to get into the car with those keys. So just as if when they stop the car and they exit order the passenger and he's detained and they cuff him and they say for safety reasons, because now this is a real safety issue. Police making these kinds of stops are real. We know that an officer has recently was shot in the same area of this, and just a few days ago, and the police cruiser was on fire. So these are real safety things. She's detained. Now, the officers could have...
But stop, just walk us through, it's like, I'm just trying to, it's a tinted window case. They stop the car for tinted windows. They see furtive gestures towards the glove compartment by the passenger. So your view is at that point, they have the right to do what? Because I just want to go one step at a time for a little while.
Sure.
So at that point, they have what? Reasonable suspicion of what? You know?
Are we talking about the point in which they are exit order or just
I'm
approaching?
I'm just trying to go one step at a time.
Okay, so one step at a time, sure.
Tinted window case. They stop the car.
And what is...
And they see furtive gestures towards the glove compartment.
Correct. And then this is there's a lot of very specific testimony about the area. There being arrests for guns, being a high crime area known specifically to these police officers. So this is not a generality of what's going on in this neighborhood around this time. Then we also have the officer gives specific testimony about the relevance of tinted windows as being something used to secrete identity, contraband, and the hiding of contraband during car stops, which he says that him and his officer recently had done 4 tinted window stops that resulted in 4 recoveries of illegal firearms. Plus, before, as they're, and you can see this on the camera, right? That you see the officer Fullman, who's on the passenger side, you see him stop. He's physically reacting to what he is observing. And then we also have Hendrick says OP. It's an OP car, which means Orchard Park, which is the gang that is around this area, and basically saying that the driver, we're dealing with a gang situation right now. So that leads the officer, and this is all on the camera, saying, listen, I'm afraid about these actions that you're making, and I'm gonna detain you now. And what is also relevant is how he reacts, right? The passenger starts reacting, and well, I'll come back to this because the driver, Dobson, then is also saying, stop it, like, relax, can I just have my ticket? And I think when we come back to the issue of voluntariness, attenuation, and independence, I think those can be characterized as deflection, self-serving, like, let's get out of here because I know I have a gun in the car. So although back to your point, the officers that hasn't happened yet in that point in time. So the officers ask him to get out. So I don't know if that answers your question. Would you like me to go further or?
Well, I don't think it's disputed that the exit order and initial pat frisk are not a problem. That's not an issue. So could you start from after the first pat frisk and why the next pat frisks were justified? So the first pat frisk being that one of the male officer at the side of the road. There are different ways we can enumerate the pat frisk. And when you say the second, would that be the pat frisk initiated by the first female officer, by the female officer?
No.
Didn't she have multiple pat frisks by the male officers before the female officers arrived? If I can just recount so that make sure we're all speaking the same thing. The first pat frisk, I think we should describe maybe as the male officer. The second would be the first pat frisk by the female. And then
Didn't both officers pat frisk the defendant after they put her in handcuffs to find the keys?
That's not necessarily how I view the camera, the footage.
Can we agree, though, that there was a pat frisk by the first male officer that yielded no weapons?
Yes.
Okay. And so at that point, and it's clear that they want the keys. They're not looking for dangerous weapons at this point. If she's not going to give them up and she wants to keep away, why not just stop at that point and say, okay, we'll get a warrant?
They do. So They don't, you're correct in that obviously they don't stop, and they're adamant about getting the keys at that point. And I think that's reflective of the dangerousness essentially of the situation. But I do want to point out that this idea of let's get a warrant is introduced at minute 27.
But I'm differentiating between saying we can get a warrant and actually stopping and getting.
So if we're going with Judge Ellis's facts, and we know that I also offer the court an alternative argument, then that first pat frisk was essentially not justified, where the first pat frisk yielded nothing. So, and she finds that both searches, pat frisk by the female officers, were illegal.
Can we agree that you can't pat frisk for evidence? You can only pat frisk for weapons.
Yes.
You can search for evidence, but you can only pat frisk for evidence.
Pat frisk is limited to whether or not there's specific and articulate facts, whether or not someone is armed and dangerous. So
and notwithstanding that Key's appointee, we'll put that aside. Clearly, they were pat frisking her or searching her for the purpose of getting the keys, right?
And that's what Judge Ellis, and I think the only way that, as the Commonwealth argues, that we get to elements of keys being an instrumentality is if the court accepts the alternative argument, which is assault and battery that leads to the keys. So
But assault and battery, that's inevitable discovery, right?
Right.
That wasn't argued below, or wasn't found below?
No. But if I could go just back to Chief Justice Budd's inquiry, because I really do understand that that's the crux of the issue that the court is facing, right? What do we do with the situation? Again, going with Judge Ellis's findings, if we have a situation where there's two illegal pat frisks, right, and then we have consent thereafter. So, and I think this dovetails with the question that Justice Dewar had asked earlier, which really amounts to an illegality, right? And then we have to turn to attenuation, and then we have to turn to voluntariness. And I think all the cases that talk about attenuation really talk about the exploitation of what is recovered as a result of the illegality. If we look at MIDI, Arias, there's many cases that I cite. It's talking about an illegality happens, the government yields something inculpatory or useful for inculpatory purposes, and then uses that illegally obtained evidence to then incentivize consent.
But that's different in the context of car stops, where continuing to keep the person by the side of the road is itself an illegality. And so sometimes it's different.
Well, I think here, if we're talking about duration, which I understand your question as being why that would be relevant, but I do think it's a different inquiry in this case, right? Because I don't think we have, this is not a traditional car stop. So that whole lineage of cases about when should, like my sisters, where we talk about what can you do, how can you expand a routine start, that is not what we have here. We absolutely have a case based on reasonable suspicion. But when we're talking about this idea of attenuation, right, assuming all these illegal pat frisks, right, where there's nothing yielded from it, there was nothing here for the police to exploit in order to incentivize her consent, meaning whatever happened in the pat frisk was not material to her consent. And what do I mean by that? What I mean is that—
Is that reality, though? I mean, I get we're making legal arguments here, but what you're selling me is that this woman, who, in your own words, was subject to illegal pat frisks for keys, not for weapons, scuffle, right, with a male police officer, right, that all of that, despite the fact that it didn't yield anything, any tangible piece of evidence that now we can use to coerce your voluntariness, that none of that had all impacted her ability to say, you know what? Okay, search the car. I mean, is that
so?
is that really what we're doing here?
Well, I agree with your characterization, but I do think it does have to be confined by the law. And it has to be evaluated in the way that the law is written, which is
Law requires voluntary consent freely given to include the evaluation of the totality of the circumstances. And I think what my colleague is saying is that we cannot ignore what I counted on the video of at least 5 illegal pat frisks, including one that was very intrusive on a public way. We can't ignore that in determining whether the consent was voluntary.
so. Yes, I think that, of course, I'm not quibbling that the whole interaction needs to be taken into account to determine voluntariness.
Even if the officers didn't, quote unquote, get the keys by frisking her that many times.
Right, but I think by that saying that this isn't really about attenuation is not an accurate reflection of how the law, what happens, about how the law is implicated in this situation.
What was the time between the last question by Officer Gonzalez under De Pina and her giving up the keys? How many seconds passed by? Because it's not a minute.
Or if I could just ask a clarifying question, is that after she's told that she has
5 times, including the one that's very intrusive, after the dog alerts and she's given an ultimatum, either we break your car by doing the tow or ransack your car in order to get the glove compartment open. After that happens and Officer De Pina and Officer Gonzalez are continuing to hound her, and then ultimately one of the male officers comes back and says, okay, I need your choice now.
5 minutes. So
5 minutes
under the shirt is at 41. And De Pina, the officer who has the keys, I got it, is at 46.
But you're saying there was silence? She was left alone during those 5 minutes?
She's not. And I think what happens during those 5 minutes, though, I think is what we have to go back to the attenuation doctrine that discusses whether or not there's independent rationale for that consent. And I suggest that this court really analyze this in that when we have under the shirt at 41, then she's told at 43 that the dog is hit. Then, which she's told we're going to tow the car. But then after she's speaking to the female officers who are very conversational, and they're like, your car is going to get ruined. And you might as well just give it up. Your car's going to get broken into and damaged. And I think that's the meaningful point, though, because up until then, she is her strong will. And I understand the court's concern with
what's
those
your
5
best
frisks,
case?
It's Kip.
For the proposition, or Kip was 2 hours between the last illegal conduct by the police, a different location. The defendant was taken to the police station. Here, as far as I can tell from the video, it's all on site, and there's seconds between the last question by the female officer and her giving up the keys.
So I still think it's Kip, and I think Kip, in a way, for colloquially, is worse than this case in that the officers did exploit evidence that was illegally obtained after the illegal action. So I think in a way this is better where there's nothing yielded. But I think what happens here is that all of those things, I think we are going to, it's really an omission if we ignore all the other significant indicia of voluntariness, where here the defendant knew she could have refused because she did.
Yeah, she had been refusing for 20 minutes.
And and that she was not in fear of the officers, where she basically engaged in a physical altercation.
And then she was handcuffed.
And then we know that she's performatively saying, why do I need the keys? Why do you need the keys? She says 3 different statements that are deflecting.
Right, so she's trying to resist and she's still being held.
And we have behavior between the illegal. I think what's really interesting and notable is that in between the pat frisk, the invasive pat frisk, if we will describe it that, her behavior, she is explaining to the officers, she's making self-serving
Yeah,
statements.
she's saying, give me my ticket. I want to go on my way. Give
Because
me
she's
my ticket.
deflecting and she's still calculating her game of keep away, which is not ultimately decided, or she
Or
doesn't
she's
ultimately come to that
exercising her
conclusion.
constitutional
until
right to
that.
have a traffic stop end when the citation should be issued.
Right, well, that is not an accurate, has to do with whether or not there's a gun in the car, and the officers have the right to dispel or hold her and the car until that suspicion is
To get a
dispelled or
warrant.
affirmed.
Can I ask you one question about your point about attenuation? If I remember correctly, please correct me if I'm wrong. You made the point that in the attenuation line of cases, there seems to be some exploitive conduct based on something, some evidence that they find that they then confront the person with that then perhaps might taint the consent. Why isn't the dog hit evidence? Why isn't that fit within that line of case? Because it was like 8:38 or 8:39 or so when the officer with the canine comes to the scene. And it was that the canine then has a tell, and then they take the fact that the canine had a hit and confront her with that. Why doesn't that fit into the attenuation line of cases that you say, hey, now they have something and they exploit that something to get something else?
If I may, Your Honor, I see that my time is up for me. Well, it's in that way, that's independent. The dog is separate and apart from all of her conduct and everything they do. So in your question, they cross, right? But they're really independent. So regardless of whether or not this dog didn't necessarily make the police go get, they would have gotten the search warrant for the search warrant for the dog anyway. So to somehow say that her, if I can just start over, I think it all would have been the same, is what I'm trying to say. It all would have been.
Did they have probable cause before they got the dog hit?
No.
So how could it all have been the same? They're holding her by the side of the road for a lengthy period.
By the same, I mean where the patch frisk yielded nothing, that illegality and anything that flowed from it is separate and apart from the valid search warrant. So it all would have been the same anyway, meaning that this illegality didn't try to incentivize her, where ultimately there would be an independent reason for the search warrant.
If we don't we don't think this is a voluntary consent, I'm just trying, is there another way that you win, or is this rise or fall on the voluntary consent?
Well, they have the independent, I think that's dovetails sort of what I just said, that where they have the probable cause to get into the car, because the car's not going anywhere until they essentially figure out what's in that locked glove box. So whether or not it's consent or whether or not it is the execution of the search warrant.
I'm just trying to get a sense. Can you still win if it's, briefly tell me how you win if this consent is not voluntary. You win because they are going to get to this glove compartment anyway. I'm just trying to understand.
Yes, they will get to the glove compartment anyway, because it's not as if they're going to let them back in the car and be like, okay, locked glove box, all set, we can't get in here. So either it's going to be, you give us the key. I mean, this is again where I go back to this game of keep away, which I think illustrates her voluntariness and ultimately. And if I could, I'm sorry, I know I'm over.
Well, I don't think you.
Yeah, go ahead.
I think